Good afternoon, or evening, or morning, or wherever you're at. I guess good morning, good afternoon, good evening. My name's Wendy, and this is Sinister, Truly Sinister. And today I wanted to go over the Karen Reed's motion to compel Colin Albert, Colin Albert's deposition. He's trying to ditch it. Apparently, he showed up for a deposition with his lawyer and some of the other defendants' lawyers, but not Karen Reed's lawyers. He's avoiding them at all costs, and we can only wonder why. So stay with me, and we'll get right to it. Okay, so it's been a minute since I've been in here. I had to work the last few nights, and in case you didn't know, I work 12-hour shifts, so trying to get in here after work is kind of hard, especially when I work out, I have to walk my dogs, do other stuff, and then I have to be back at work in 12 hours, so I don't have much time for anything when I'm working a stretch. So there's that. Um, so yeah, the fighting, Reed's team has been fighting to get Colin Albert's deposition in the uh, wrongful death case against her by the O'Keefes. And he's given them the runaround, as well as the rest of the McAlberts. They're all, dicking the dog, so to speak, and they're just not doing what the judge wants them to do. And the judge is honestly getting a little sick of it. He's getting irritated. You could tell he's not having a good time. And he's just about had it with these people. He's tired of the games and the pettiness. So apparently, Colin Albert notified his lawyers that he was going to be unavailable until fall due to work. And so he only had a handful of days that he was available in the end of May. Well, none of those dates worked for Karen Reed's team, so they weren't able to do it. They didn't schedule it. Apparently, he met and did a deposition with just his lawyers and the Waterfall and the McCarthy's lawyers. And that's just not good enough. I'm sorry. That doesn't cut it. That doesn't count. And then he, of all things, joined the Army on June 2nd. Right? The things people won't do to get out of a deposition. It's kind of crazy. Mind-blowing, to be honest with you. So they showed up. They had a, was it today or yesterday? And it was yesterday. And his have freezing problems again. And the judge said, not going to happen. You're going to go out there and when you come back on Monday, you're going to give me some dates that he's available to come do his deposition. I don't care if he's in the Army. I don't care if he's in boot camp. He's going to give you some days, and he's going to be here before the discovery period ends, which is in August, I believe, August 17th or 27th or whatever. And the funny thing is Chris Albert and Jennifer McCabe were both at this hearing, which neither one of them are involved in this case. They're non-parties of this case. It's the O'Keefes and Karen Reed. So you can only imagine that they're there to find out what's going on as where Colin's concerned, as far as his deposition and whatnot. So they didn't look happy, to say the least, which, oh well, this isn't about you. But it's just that kid. I mean, did he really think that was joining the Army was going to get him out of doing a deposition? Not to mention, he just filed a lawsuit against Karen Reed. He's one of the Haas defendants, who just filed a defamation lawsuit against Karen Reed and Aidan Carney. So how are you going to initiate a lawsuit against someone, and then take off for the next 3 or 4 months? How does that work? And that's what the judge said too. He said, don't forget that I know that you represent him in another case that he just filed, and he needs to make himself available. So I don't know what's going to happen. He has to have some dates. The judge scheduled another status hearing on Monday, and he better have some dates for the judge, or I don't know what's going to happen. But the judge was not happy. He ain't having it. And I don't blame him. So we're going to go over Karen Reed's motion to compel. It's kind of crazy, to be honest with you. All of this is crazy. The whole Miles King thing is crazy. Before we go on, I forgot to... I knew there was something that I wanted to tell you, and I don't have a video queued for it or anything, but Alvin Campbell was found guilty on all charges. So his sentencing, I believe, is in... Just one second. Is in July or August. Just one second. So maybe before we wrap things up here tonight, I can find a quick video. Of course, it wasn't streamed, it wasn't aired, because you have the victim impact statements and whatnot. And so yeah, they weren't about to do that. Just a second, I need to fix my camera. Okay, this is as good as it's gonna get for tonight. Anyway, but yeah, I knew that I wanted to get back to you guys about that, and things happened and motions were made and shit, and I just totally forgot about it. So I apologize about that, but that was good news. So yeah, my hair looks atrocious. I was out working on the sprinklers, and of course, when I went to adjust one of them, it sprayed me dead in the face. So yeah, you gotta love it. Okay. That's not what I wanted to do. It's always something, I'm telling you. Okay. Defendant Karen Reed's memorandum of law in support of motion to compel Colin Albert to attend deposition and produce documents pursuant to third-party subpoena. Defendant Karen Reed respectfully requests that the court compel Colin Albert to attend deposition and produce responsive documents pursuant to a validly issued subpoena. As detailed in the attached emails, what were normal communications between counsel of a subpoenaing party, Miss Reed, and non-party witness, Colin, devolved into another episode of gamesmanship. Unfortunately, the court now needs to step in. Remember what Jennifer McCabe said in their little group chat about if she pleads, it's all over. If she doesn't, it's going to be a whole nother episode. It's funny that they use episode, or that she uses episode, right? I wonder if that's a little twist of that knife. Background facts. Colin Albert has relevant information pursuant to Mass R Civil P26. Colin Albert was at 34 Fairview Road the night John O'Keefe died. He had a history of violent tendencies, and specifically, he and Mr. O'Keefe had a series of prior disputes. On the night Mr. O'Keefe died at the house, Colin had been drinking alcohol with his friends, and that drinking party continued at the house late night. That's a weird sentence. The exact time Colin left the house is a heavily disputed fact in this case. Regardless, however, when Mr. O'Keefe arrived at the house around 12:30 a.m. on January 29, 2022, the medical evidence demonstrates conclusively that he was beaten up, punched in the face, and knocked backwards, sustaining a fatal wound to the back of his head on a ridged surface, remember? In the immediate aftermath, those individuals in the house, referred to as house defendants in Miss Reed's federal court action, attempted to cover up their role in Mr. O'Keefe's death. For Colin's part, he claims he left prior to Mr. O'Keefe's death and was picked up from the house by his best friend, Allie McCabe, and driven straight home. However, the timing of his arrival at home is inconsistent with when he claims he departed the house. Moreover, in a photograph taken shortly after January 29, 2022, Colin had scabs on his knuckles of his dominant hand that one would expect to see as a result of a fistfight. Additionally, Colin is tightly connected both to the House defendants and the lead investigator for the Massachusetts State Police in the death of Mr. O'Keefe. Specifically, Colin is the nephew of Brian Albert, who owns the house. Allie McCabe is the daughter of House defendants Jennifer and Matthew McCabe. Brian Albert and Jennifer and Matthew McCabe were all at the house when Mr. O'Keefe died. Colin was also close family friends with Michael Proctor, the conflicted and corrupt MSP investigator that refused to investigate the House defendants and attempted instead to quote-unquote pin it on the girl, Miss Reed. Not only was Colin at Proctor's sister's wedding, he was in Proctor's sister's wedding party. Proctor's mother circulated a public Facebook post in October of 2019, declaring the Alberts as, quote, the Proctor's second family, end quote, and includes a photo of Colin Albert and his parents. Among a mountain of evidence demonstrating that Proctor attempted to unlawfully protect those in the house, Proctor's written notes he took early in the investigation show he knew Colin was in the house that night. But when he prepared his quote-unquote official report, he omitted Colin's name to hide his involvement that night. Not to mention, he said he didn't take notes. He totally perjured himself on the stand. That's a thing with these guys. Despite being present at the house after midnight on January 29, 2022, Colin was not interviewed by the MSP until July 18, 2023. In a report of the interview, Proctor writes that Colin was picked up shortly after midnight by Allie McCabe, revealing for the first time the presence of yet another witness, Allie, and another vehicle, hers, outside the house that was never. Despite this quote-unquote new information, Proctor failed to confirm Colin's statements by seizing his cell phone, or Allie's, or pulling carrier records. He just took Colin's word for it, or rather took his father, Chris Albert's word for it. On September 1, 2023, Trooper Yuri Buchanan authored a 6-sentence report stating that he had contacted Colin, quote, in an attempt to have him turn over text messages he had captured screenshots of between Allie McCabe and himself on January 29, 2022, end quote. There is no report memorializing what prompted Buchanan to call Colin, how Buchanan had obtained Colin's phone number, or how he became aware that Colin was suddenly in possession of text message and evidence. In his report, Buchanan goes on to say that he contacted Chris Albert because Chris, not Colin, was in possession of screenshots of Colin's and Allie's text messages. Yeah, Jennifer McCabe had copies of Allie's text messages or screenshots, and Chris Albert had screenshots of Colin's, which I think is totally weird. These messages were shared by the NDAO, Norfolk District Attorney's Office, as mere cut and pastes of screenshots of texts into a PDF document. They contain no metadata to confirm their accuracy, nor is there any audit trail of when and how Chris Albert came into possession of Colin's messages. These texts, their origin, and most importantly, their metadata, help prove the whereabouts of relevant witnesses on January 29th, as well as communications among the Alberts, Proctor, and Buchanan that are not otherwise memorialized. Not only did MSP investigators fail to seize Colin's phone, they failed to seize Chris Albert's or Allie McCabe's phones and merely relied on screenshots of supposed messages passed from witness to witness without any authentication. Yeah, I mean, instead of taking a screenshot of the text message, why didn't you just forward the text message so that all the metadata and everything went along with it? Or better yet, why not just give your phone to the police and let them extract the text messages so they make sure that they get everything they need? Because they didn't want it. That's why. And the text messages didn't exist. Matthew McCabe is a IT wizard, remember? Data downloaded from the Life 360 application on Jennifer McCabe's phone shows time-stamped notifications of Allie McCabe's arrivals and departures from addresses throughout the early morning hours of January 29th. Not only does the Life 360 data prove that Allie McCabe did not travel straight home after dropping off Colin, as she told Buchanan in an August 25, 2023 interview. More importantly, the data shows no evidence of an arrival or a departure from 34 Fairview or Colin's house at any time on January 29th. Let me read that again. I don't think we knew this. Not only does the Life 360 data prove that Allie McCabe did not travel straight home after dropping off Colin, as she told Buchanan in an August 25th, 2023 interview. More importantly, the data shows no evidence of an arrival or a departure from 34 Fairview or Colin's house at any time on January 29th. So according to this, according to her Life 360, she never even went to 34 Fairview that night. So she perjured herself on the stand. Wow. But Jennifer McCabe said that the Life 360 wasn't very accurate. But it's accurate when she needs it to be, right? I mean, when she needs it to tell them that she was somewhere, then yeah, it's accurate. Just like, the Cellbrite isn't accurate unless they need it to put Karen Reed somewhere. Then it's accurate. How she knew Colin was at the house on January 29th, and no communication from Colin relaying his location to Allie is included in the screenshots of their text messages. For these reasons and more, Colin has relevant information about what happened the night of January 29, 2022, his communications with the House defendants and others concerning Mr. O'Keefe's death and Proctor's investigation. Indeed, his role was so important to the Commonwealth that it called him as a witness in Miss Reed's first criminal trial. Miss Reed's attorney served subpoena upon Colin and then attempted in good faith to narrow the scope of that subpoena after objection. On February 11, 2026, Miss Reed's attorney properly served a notice of taking deposition of Colin Albert for April 29th. See notice of taking deposition attached hereto as Exhibit A. On April 21, Miss Reed's attorney also properly served a subpoena upon Colin. See subpoena attached hereto as Exhibit B, including affidavit of service. Let's see, do we have the... Do we have the exhibits? I don't think we do. Oh, maybe we do. So we want Exhibit A and B. I guess we don't have those exhibits. Oh, yeah. Okay, here's his notice of deposition with the, okay. And then the subpoena ducis tecum, I don't know how to say that, where it commands him to show up for the deposition. So, now where were we? The subpoena required Colin to attend a deposition and bring with him documents related to the case. Specifically, the subpoena required production of documents in Colin's possession related to the MSP investigation, Miss Reed's criminal and civil cases, and his communication with the MSP investigators, the quote-unquote House defendants, and others directly associated with the case. On April 27th, the attorneys who represented the House defendants identified that they were representing Colin and served a Rule 45 objection upon Miss Reed's counsel, including objecting to the scope of the request for the production of documents. See April 27th email, including Rule 45 objection, attached hereto as Exhibit C. Well, let's first go ahead and read the first two exhibits since we okay, Exhibit A is the notice of deposition. Please take notice that at 10 a.m. on April 29th, 2026, defendant Karen Reed, by her attorneys, will take the deposition and Green, Pennsylvania, or PA, 28 State Street, 22nd floor, Boston, Massachusetts, 02109, before a notary public or before some other officer authorized by law to administer oaths. The deposition will continue day to day as necessary and will be recorded stenographically and by audiovisual means. You are invited to attend and cross-examine. Respectfully submitted, Karen Reed, by her attorneys. And the certificate of service. And then Exhibit B is subpoena ducis tecum. I don't know how to say that, but anyway. Greetings. You hereby are commanded in the name of the Commonwealth of Massachusetts, pursuant to the provisions of Rule 45 of the Massachusetts Rules of Civil Procedure, to appear and testify on behalf of defendant Karen Reed at the offices of Sheehan, Finney, Bass, and Green on April 29th, 2026 at 10 a.m. and to testify as to your knowledge at the taking of the deposition in the above entitled action before a notary public in and for the Commonwealth of Massachusetts. Furthermore, you are required to produce the documents listed in the Schedule A attached hereto by April 27, 2026 at 12 p.m. Let's see what the list is. Karen Reed is the defendant. John O'Keefe is his agents or attorneys or other representatives. Michael Proctor is the MSP trooper. Chris Albert, Julia Albert, Brian Higgins, Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, Courtney Albert, Carrie Roberts, Brian Albert Jr., Paul O'Keefe, Kevin Albert, and Allie McCabe are individuals or their attorneys or the representatives. Okay, this just gives all the definitions. Documents withheld. If any document is withheld under a claim of privilege or other protection so as to aid the court and the parties hereto to determine the validity of the claim of privilege or other protection, please provide the following information with respect to any such documents. A. The identity of the person who prepared the document, who signed it, and over whose name it was sent or issued. B. The identity of the person or persons to whom the document was directed. C. The nature and substance of the document with sufficient particularity to enable the court and parties hereto to identify the document. D. The date of the document. E. The identity of the person or persons who has custody of or control over the document and each copy thereof. F. The identity of each person to whom copies of the document were furnished. G. The number of pages. H. The basis on which any privilege or other protection is claimed, and I. Whether any non-privileged or non-protected matter is included in the document. 2. Partial protection. If you object to a particular request or portion thereof, you must produce all documents called for which are not subject to that objection. What? If you object to a request or portion thereof, you must produce all documents. Similarly, wherever a document is not produced in full, please state with particularity the reason or reasons it is not being produced in full, and describe to the best of your knowledge, information, and belief, and with as much particularity as possible, those portions of the document which are not produced. 3. Or you think he understands any of this? I can guarantee he doesn't, because I barely understand it. 3. Orderly response. Wherever it is reasonably practicable, please produce documents in such manner as will facilitate their identification with the particular request or category of requests to which they are responsive. 4. Construction of and or. As used herein, the words quote-unquote and quote-unquote or shall be construed both conjunctively and disjunctively, and each shall include the other wherever such dual construction will serve to bring within the scope of these requests and any documents which would otherwise not be as used here in the singular form shall include the plural and vice versa, whenever such dual construction will serve to bring within the scope of these requests any documents which would otherwise not be brought within its scope. Format For production, for all documents currently stored in electronic format, produce those documents in their electronic native form with all metadata intact. For example, emails should be produced in PST format, and audio and video recordings should be produced in their native forms with all metadata intact. So unlike their screenshot of their text message, that's what not to do. If you intend to produce documents in a format other than that specified in these instructions, please notify plaintiff's counsel before making the production. 7. Supplementation required. To the extent you obtain possession, custody, or control of a document that is responsive to these requests, after you make your production in response to these requests, you must supplement that initial production with the newly acquired document. Schedule A, Colin Albert is required to produce by April 27th at 12 p.m. the following. A, all documents including communications relating to Karen Reed. B, all documents including communications relating to John O'Keefe. C, all documents including communications relating to Michael Proctor. D, all documents including communications relating to the investigation. E, all documents including communications relating to the criminal trials. F, all documents including communications relating to the civil actions. G, all communications with Michael Proctor. H, all communications with John O'Keefe. I, all communications with Paul O'Keefe. J, all communications from January 28, 2022 to the present with Chris Albert, Julie Albert, Courtney Elberg, Carrie Roberts, Brian Higgins, Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, Allie McCabe, Brian Albert Jr., and or Yuri Buchanan. And then the affidavit of service. I, Brian Silva. So, whoever that is. So, yeah. I'm sure you had to have somebody go through that with them, because I wouldn't have known what the hell they were asking for. Okay, so where were we? Were we only on page 4? On April 27th, the attorneys who represent the House defendants identified that they were representing Colin and served a Rule 45 objection upon Ms. Reed's counsel, including objecting to the scope of the request for the production of documents. See, oh, that's what we started to go down. That's what we went down there for originally, right? See April 27th email attached here to his Exhibit C. One of counsel's primary objections was the quote-unquote scope of the request for communications with his parents from January 29th, 2022 to the present. However, Colin's counsel did not claim that the subpoena was quote-unquote ineffective. So let's go to Exhibit C. An email from Kieran Murphy. Aaron, attached, please find non-party Colin Albert's responses and objections to the subpoena ducis tecum that was served on him on April 21, 2026. Non-party Colin Albert's objections and responses Massachusetts Rule of Civil Procedure 45, non-party Colin Albert, by his attorneys, hereby make these objections and responses to defendant Karen Reed's subpoena ducis tecum, served on Mr. Albert on April 21, 2026. Mr. Albert reserves the right to amend or supplement his responses to the subpoena as this litigation proceeds. General objections. As a general response to all categories of documents and written communications sought in the subpoena, the quote-unquote request, Mr. Albert responds and objects as follows. 1. Mr. Albert objects to the request since they fail to comply with the notice requirements outlined in Mass RCP 45. Quote, a subpoena upon a third party which commands the production of documents, electronically stored information, or other things must give the party at least 30 days for compliance after service thereof, end quote. Number 2, Mr. Albert objects to the request to the extent they seek information that is subject to the attorney-client privilege, work product doctrine, joint defense, or common enterprise privilege, or other privilege on the ground that it is exempt from discovery. Number 3, Mr. Albert objects to the request to the extent they seek information that is not within the possession, custody, or control of Mr. Albert. Number 4, Mr. Albert objects to the request to the extent they seek information that is unreasonably cumulative or duplicative or is obtainable from some other source that is more convenient, less burdensome, or less expensive. 5, Mr. Albert objects to the request insofar as they seek to impose upon him burdens and obligations different from those required under the Massachusetts Rules of Civil Procedure. 6, Mr. Albert objects to the request to the extent they are vague, ambiguous, overly broad, and not identified with reasonable particularity. 7, Mr. Albert objects to the request to the extent they seek information constituting or containing trade secrets, confidential and or proprietary business information. I'm not quite sure what business information would be contained in any of this. Number 8, Mr. Albert objects to the request to the extent that they purport to require him to provide information that is publicly available and or already in Ms. Reed's possession, custody, or control. 9, Mr. Albert objects to the request to the extent that they purport to impose a duty on Mr. Albert to seek information or documents through something other than a reasonable search of files where potentially responsive materials or information reasonably would be expected to be found. 10, Mr. Albert objects to the request to the extent that they call for a production of, quote, all, any, each, or every document as overly broad and unduly burdensome and fails to describe the documents sought with reasonable particularity. Just one second. Sorry about that, my dog's going crazy. Number 11, nothing herein shall be construed as an admission by Mr. Albert as to relevancy or admissibility at the trial of this matter of any information that he may produce in response to Ms. Reed's requests or any information contained in any of these responses. Number 12, Mr. Albert does not waive any of his general or particular objections in the event he furnishes information or documents coming within the scope of any such objections. And number 13, Mr. Albert objects to the time frame of these requests as overly burdensome and not likely to obtain relevant information. Specific objections and responses. Request A. Okay, request A. All documents including communications relating to Karen Reed. Response to request A. Mr. Albert objects to this request on the grounds that it fails to supply him with the adequate time to respond, in violation of Mass R Civil P 45D1, having only been served on him 6 days prior to the return date. Mr. Albert further objects to this request on the grounds that it is overly broad, unduly burdensome, vague, ambiguous, and seeks documents and information that is neither relevant nor reasonably likely to lead to the discovery of admissible evidence. Mr. Albert further objects to this request to the extent that it seeks documents that are protected from discovery by the attorney/client privilege, the work product doctrine, and or any other privilege cognizable at law. Mr. Albert further objects to this request to the event that it seeks documents and information already in Ms. Reed's possession, custody, and control. Based on the foregoing objections, Mr. Albert will not produce documents in response to request A. Oh, so he won't. It's going to really go through each and every one. Oh my God. Request B, all documents including communications relating to John O'Keefe. Response to request B. Mr. Albert objects to this request on the grounds that it fails to supply him with adequate time to respond in violation of, gives the code, having only been served on him 6 days prior to the return date. Mr. Albert further objects to this request on the grounds that it is overly broad, unduly burdensome, vague, ambiguous, and seeks documents and information. Okay, basically it's the same thing. So he's refusing. He's informing them that he will not produce these documents also. Request C, all documents including communications relating to Michael Proctor. And his response to request C is the exact same as the above. Request D, communications regarding the investigation, and his response to request D appears to be the exact same. Request E. All documents and communications relating to the criminal trials. His response is the exact same as the above responses. Request F, relating to civil actions. His response is the exact same. So it's basically a generic blanket response. So I don't know why he's going through each one individually when he's giving the same response to all of them. It makes no sense. Response G about Mr. Michael Proctor is the exact same. Communications with John O'Keefe, his response is the exact same. Request I, communications with Paul O'Keefe, response is the exact same. And request J, all communications from January 28, 2022 to the present with, all these people. His response is the exact same. Dated in Boston, Massachusetts on this 27th day of April. Colin Albert by his attorneys. Wow. Just wow. Okay, so let's go back up to where we were. Jesus Christ. Okay, that same day, April 27th, Miss Reed's counsel requested a Superior Court Rule 9C conference relating to the objections, wrote that, quote, it makes sense to take Colin Albert's deposition after documents are produced, end quote, and agreed to, quote, unquote, reschedule the deposition so they could address the objection. See emails attached hereto as Exhibit D. Miss Reed's counsel did not, quote unquote, withdraw the subpoena or cancel the deposition, and Colin's counsel did not take the position that the subpoena was, quote unquote, ineffective. Rather, on April 28th, counsel for Miss Reed and Colin conducted a 9C conference to narrow the dispute concerning the requests for documents. During that conference, Colin's counsel did not take the position that the subpoena was, quote unquote, ineffective, nor did Miss Reed's counsel, quote unquote, withdraw the subpoena or, quote unquote, cancel the deposition. But they did discuss the possibility of narrowing the scope of the subpoena. As a result of that conference, the very next day, April 29th, Miss Reed's counsel provided a proposed narrowing of the subpoena's requested documents, specifically addressing the main concern, which was Colin's communications with his parents. See ID and attachment. Specifically, Miss Reed proposed to narrow that request to a 4-month period immediately following Mr. O'Keefe's death, and counsel asked for a response to the proposal. See ID. Rather than respond in good faith, Colin's counsel began efforts to thwart the subpoena entirely. So let's look at Exhibit D, shall we? I don't know what page it was. Exhibit D. Email from Aaron Rosenberg to Christopher Matei. Chris, thanks for the call yesterday. I've thought through your team's proposals on consolidation and the subpoena to Colin Albert and have discussed them with our group. We do not agree to consolidate discovery in your client's defamation case with the O'Keefe litigation. As we discussed, we are already well down the road in discovery in that case with almost all documents produced, multiple rounds of interrogatories and answers exchanged between all parties, and over 20 depositions scheduled in the upcoming months. Also, Judge Gildea has been insistent that we do all we can to stick to the existing discovery deadline in August, and I don't believe he would be inclined to allow the consolidation that would necessarily require a significant extension of that deadline. Also, although I know you weren't yet involved in the case, your clients previously resisted our efforts to make these proceedings more efficient by bringing our claims against them in the O'Keefe case last year. Then, when we filed those claims in a separate superior court action, they removed it to federal court, preventing any chance of consolidation. We do not think now consolidating only your affirmative claims, which your clients opted to bring in yet another proceeding rather than in the existing federal case, would be efficient or fair. Attached is a proposed narrowing of the document subpoena to Colin Albert, particularly the portion of the last request seeking communications with Colin Albert's parents, as you requested in our 9C call. Please let us know if you will agree to produce documents responsive to these narrower requests. We reserve the right to seek additional categories of documents in the future pursuant to the applicable rules, but are willing to accept this scope of documents at this point prior to the deposition. Thanks, Aaron Rosenberg. So this is the new schedule that they said they want him to abide by, and I'm not sure what the differences are, but apparently it's more narrow, so there's that. Wow. Okay, so let's move on, shall we? Where were we? That's Jesus Christ. Wow. Where was I? Okay. That was Exhibit D, right? Okay. Tonight in C conference. There's a rule of that conference the very next day. Okay. For 3 weeks, Colin's attorney entirely ignored Miss Reed's April 29 request for a response to the narrowing of the subpoena. Miss Reed's counsel then reached out again on May 19th, specifically asking for a response to the narrowing, the production of responsive documents, and deposition dates in June. See emails attached here too as Exhibit E. Oh, God. On May 20th, Colin's counsel wrote that Miss Reed's proposed narrowing was still, quote, not appropriately scoped, end quote, but did not address which paragraphs, what documents would be produced, or any deposition dates. Colin's counsel did not take the position that the subpoena was ineffective. In response, on May 20th, Miss Reed's counsel inquired about which paragraphs were not appropriately scoped and asked again for deposition dates in June. At 10 p.m. on May 20th, Colin's counsel wrote that they had conducted, quote, a reasonable search, end quote, but that they are unwilling to produce any responsive documents. Worse, Colin's counsel stated for the first time that Colin would be out of town indefinitely after June 2nd and would only be available on May 28th or May 29th. Again, notably, Colin's counsel did not take the position that the subpoena was ineffective. On May 21, in response, and inquired about dates in June, why Colin couldn't come back for any dates in June, and why notice wasn't given before 10 p.m. on May 20th that Colin would suddenly be gone indefinitely. He also asked more questions about the reasonable search conducted for the documents and what responsive documents they had for each category that they were contending was unduly burdensome and overly broad. Colin's counsel did not respond on May 21. Rather, the very next day, and after Miss Reed's counsel advised that he was out of state on May 28th, plaintiff's counsel sent an email on Friday afternoon of Memorial Day weekend stating that he had communicated with Colin's counsel, that Colin's counsel had, quote-unquote, accepted a subpoena for Colin's deposition for May 28th, that he intended to proceed with the deposition on that date, and then attempted to serve an invalid notice of taking deposition among the parties. Footnote 1. Mass R. Civil P. 30 requires that a party intending to take a deposition serve a notice of taking deposition on all parties 7 days in advance of the deposition. Here, plaintiff failed to comply with the rule's strict guidelines, and therefore a valid deposition cannot proceed. Indeed, this is the exact type of gamesmanship prescribed by courts and practitioners everywhere. Wow, just wow. See email attached hereto as Exhibit F and attachment. This was obviously a coordinated effort between Colin's counsel and plaintiff's counsel to interfere with Miss Reed's subpoena and the Superior Court Rule 9C process. So Exhibit E and F we need to do. Oh my God, this is a pain in the butt going back and forth. D. Okay. Exhibit E. From Charles Waters. To Christopher Mattei, Kieran, Tuxbury. Okay. Kieran, 1. You must have missed my earlier response to Chris's email. I've placed it below chronologically for clarity in our communications. 2. Your statement below that, quote, no further documents exist that you are willing to produce at this time, end quote, is, of course, the exact issue with which we are concerned. 3. Please describe the, quote, unquote, reasonable search you claim to have conducted. 4. Please produce all responsive documents that you are, quote, willing to produce at this time, end quote, pursuant to the reasonable search, regardless of whether you think Miss Reed may or may not have them already. 5, relating to the responsive documents that you are, quote, not willing to produce, end quote, please identify what they are, including A, are there any responsive documents relating to the investigation, criminal trials, and civil actions? How many? B, regarding Colin Albert's parents, what is the volume of responsive documents? As you know, we've reduced the scope to communications in a 4-month period. And C, other than his parents, did your reasonable search identify any responsive communications with Paul O'Keefe, Courtney Elberg, Carrie Roberts, Brian Higgins, Brian Albert, Nicole Albert, or Matthew McCabe, Jennifer McCabe, Allie McCabe, Brian Albert Jr.? 6, were there any responsive documents that you, quote, are not willing to produce, end quote, relating to all communications with Chris Albert or Julie Albert? And it gives the dates of all these people and the dates. And this includes David Yannetti, Alan Jackson, Robert Alessi, FBI. 7, as for Colin Albert's deposition, we served him with a subpoena on 4/21 for a deposition scheduled on 4/29. We began communicating with your office on 4/23. Last night's email, 5/20, was the first time you told us that Colin Albert is away from the Massachusetts area for a significant period due to work-related matters to 2026. You then provide 2 dates next week for his deposition, both of which do not work for me because I am out of the state both days. Please provide additional dates in June as I requested yesterday. It is necessary for Mr. Albert's schedule. If necessary for Mr. Albert's schedule, I would consider taking his deposition on a Saturday. If you claim to have no dates in June, please explain the details of why Mr. Albert cannot come to Massachusetts at any time in the month of June for his deposition and when you first learned this. I look forward to your response, Chaz. And then Exhibit F is from Mark Diller. Please, counsel, please note the following. 1. Tuesday's deposition of Makowski is off while the O'Keefe and Reed teams confer on Reed's objections to the matter. 2. We were not notified that Miss Collins and Miss Bombardier need to reschedule the Thursday depositions. 3. Given that all parties were already blocked for the day and our need to move depositions forward, we investigated and discovered that Colin Albert's deposition was canceled by the Reed team previously and never re-noticed subpoenaed to date. Albert's counsel has agreed to accept the subpoena and to appear next Thursday at his counsel's office for deposition. See attached deposition notice, which has been properly served on Albert with a confirmed appearance. 4. Friday's deposition remains on the calendar and has been confirmed that it is going forward. Have a nice holiday weekend. I look forward to seeing you all next week. What a dick. Wow. Okay then. So, exhibit. Okay. Okay, per their plan, an hour after plaintiff's counsel's email, Colin's counsel then responded to Miss Reed's counsel's May 21 email and took the position for the first time that Miss Reed's subpoena was now ineffective. See email attached hereto as Exhibit G. He did not explain why the change in position or what occurred between May 21 and May 22 that suddenly made it ineffective. Additionally, he refused to provide any dates in June, explain why Colin could not come back for a deposition after June 2nd, nor describe what quote-unquote reasonable search he had conducted, or what documents he obtained related to that search. He did, however, reconfirm that Colin did not intend to produce any responsive documents. So let's look at G. Jesus Christ. God, what a pain in the ass. D, E, F, G. Okay. Kieran Murphy to Charles Water, Rosenberg. Chaz, respectfully, I decline to engage in a line-by-line dissection of our responses and objections to the subpoena. This subpoena was issued to a non-party pursuant to Rule 45, and as you are well aware, non-parties are afforded specific protections from undue burden under the Massachusetts Rules of Civil Procedure. We have made our position clear that this subpoena exceeds permissible bounds and violates those protections. Moreover, we have now inquired twice without receiving any response regarding the relevance of Colin Albert's testimony to the wrongful death action. The disposition of that case requires answering a singular question: whether your client is responsible for the death of John O'Keefe. Colin Albert was not present at 34 Fairview at the time of Mr. O'Keefe's death, and you have provided no explanation as to how his testimony assists in resolving Notwithstanding the foregoing objections, we have attempted to, in good faith, to reach a reasonable compromise by agreeing to produce the following categories of documents. 1. Communications from January 28, 2022 to present between Colin Albert and Michael Proctor, Yuri Buchanan, or any other law enforcement official associated with the investigation and criminal trials of Karen Reed. And 2. All communications between Colin Albert and any other individual at or around January 28th, 2022 pertaining to the circumstances surrounding the death of Officer O'Keefe and the investigation conducted into the same. I have confirmed that only a single text exchange is responsive to those categories. Communications between Colin Albert and Allie McCabe regarding the time Miss McCabe picked up Colin Albert at 34 Fairview. That text exchange was used by Miss Reed's criminal defense counsel during Colin Albert's cross-examination at her first trial, which supports our position that it is already within Miss Reed's possession, custody, and control. However, as I previously stated, if for whatever reason Miss Reed no longer has access to that exchange, we are prepared to produce it upon the issuance of a new subpoena, as the prior subpoena has expired and was not renewed. Regarding Colin Albert's deposition, we've received a subpoena today from the plaintiffs in the wrongful death suit for his deposition on May 28, 2026. Finally, I am not in a position to provide further detail regarding my client's availability constraints beyond what has already been communicated. Colin Albert will be unavailable for an extended period of after June 2, 2026 due to work-related obligations. Accordingly, we look forward to completing his deposition before that date. Regards, Kieran T. Murphy. So there's that. So now we need to, okay, that's Exhibit G. Argument. The argument here can be brief. As described above, Colin is a relevant witness in this case. Why, if he wasn't there? Ms. Reed properly served a subpoena upon him and properly noticed his deposition among the parties. Colin asserted an objection to that subpoena, and the parties then began negotiating the scope of the documents requests. On May 21, when pressed on deposition dates, the reasonable search they conducted and responsive documents Colin had in his possession, suddenly Colin's counsel position changed, and they unilaterally declared the subpoena ineffective. The subpoena is not ineffective, and the court should compel Colin to comply with it. Regarding his attendance at deposition, the court should order his counsel to provide 5 dates in June and July, other than June 25th through July 3rd, for his deposition, from which Miss Reed's counsel will choose one. As for the scope of the requested documents, Miss Reed's proposed narrowing is appropriate. Specifically, it seeks documents in Colin's possession relating to Miss Reed, Mr. O'Keefe, the quote-unquote investigation, criminal trial, and civil actions, all defined terms. It also requests communications from a list of individuals, all directly related to this matter. The one specific area about which Colin's counsel raised a concern during the Superior Court Rule 9C conference was communications with Colin's parents, who were coordinating Colin's actions in the aftermath of Mr. O'Keefe's death and serving as conduit between Colin and the Massachusetts State Police investigators. But as a compromise, Miss Reed proposed to narrow the period to just a 4-month period immediately after Mr. O'Keefe's death. That too is appropriate, and the court should order the production of all responsive documents within 5 days of its order. On the other hand, Colin's counsel's communication on May 22nd is quite revealing in its refusal to explain anything about the reasonable search that they claim they did and what responsive documents they have. Indeed, they intentionally obscure addressing the responsive document they've found, despite making arguments about overly broad or unduly burdensome. For example, if there exist 100 text messages in responsive to the subpoena, that's not overly broad or unduly burdensome, but they refuse to provide Reed's counsel, who was prepared for this deposition, will be out of state. The court should not countenance this type of conduct. Respectfully submitted, Karen Reed, by her attorneys. Yeah, they find out that Karen's attorneys are going to be out of state, so what do? They propose that date to the plaintiff's attorneys, to the O'Keefe's attorneys, and of course they accept it, and so the quote unquote deposition goes on, but it's not a valid deposition because Karen Reed was not available to make it to that deposition. So, oh my God. These, and the thing is Colin's lawyer is defending all of them, or representing all of them, which I think is a conflict of interest. I don't know how that's going to work. But what a mess, I mean, what a mess. So anyway, tomorrow I will go over the Colin's opposition to this motion to compel, and I think that's actually quite long. His attorney is quite winded, so that may take two streams, but I will do my best to get those out within the next day or two. Hopefully I can put them both out on the same day so you can just binge watch them. But yeah, I hope everybody I mean, that was kind of a boring one. The language was just too voluptuous for me. I don't like that. I don't get a lot of it, and so I mean, I'm a layman, and so I'm trying to help other laymen understand as much as we can in these court proceedings, because sometimes I get lost when I watch all the lawyers. So hopefully that it's helpful when a bunch of us just normal people get together and read through these things and kind of support each other on what things mean, how to pronounce things, whatever. Anyway, don't forget to like, comment, and subscribe. It's free, and I would appreciate it. And don't forget, every day is the first day of the rest of your life. So see you later. Ciao for now. Bye.